Just a reminder people that unless police have previous evidence or a tip-off that they cannot search your car unless they see some type of drug or drug paraphernalia or something else illegal in plain view from the windows. They will try to use tricks like saying they have a dog on the way, but that is 99.99% likely to be a lie unless there is an operation in that area at the time and they actually have the time and resources. They also try to use tricky words as a question, tricking you into consenting to a search. For example, instead of "May I search your car please sir/ma'am," they will say "Have you got anything in the car like drugs or weapons?" You reply "No," then they say, "Well, I'll just start searching it then, okay?" Which you get object to on grounds of no probable suspicion of illegal evidence. Rejecting a car search is not probably suspicion for a police officer to start searching your car. However, a police officer may pat you down by law, and if they feel something that isn't quite right in your pockets or legs, arms or taped to your body, or sticking up from your belt like where some people could hide a knife near their crotch, where police cannot, pat, like a syringe, a weapon, or some TNG like that, they can ask you to show them what it is. However, you cannot be searched for no reason other than this general weapon pat-down. I am writing this because my friend was tripped into a consented search last night when pulled over for not having his new Rego sticker apparently, and they tricked him and started searching the car. One of the cops looked in the back of the car and found an uncapped syringe in the back of the driver's seat. She swore and then yelled that if she got pricked by it she would risk being convicted by getting her husband to bash the fucking shit out of him. They continued searching the car and found probably about 500 or more syringes, most in black boxes, in the boot. Spoons and knives, some with slight residue. Empty baggies with slight speed residue, a bunch of empty G vials that were empty which they just disposed of, and G measuring syringes. They also found in Diley what they thought to be about an ounce or so of ice, but he explained to them it was Epsom salts and said they could taste it. She didn't taste it and left the salts in the car. They also found a box of pseudo containing cold and flu pills in a different name but did not take those. He is being charged in the local court with the following charges: possession of utensils used for dangerous drugs, possession of a dangerous drug, the residue left in the baggie, improper storage of used syringes. The uncapped one. They arrested him and took him to the station, and apparently while searching his car after finding the first few things, they cuffed him very tightly and locked him in the back of the car with no windows down when it was very hot and charged him. Took his prints, pictures, etc. Then recorded him with them asking a few questions. He pretty much told them indirectly or maybe directly he has used speed before, and they said that he will probably get another charge for past possession and past use as well, which I didn't think existed. BDW, this happened on the Gold Coast. Note: please keep in this forum as legal is post-moderated and has very little traffic of Australian members. Dave 8218-03-2007, 08:14. What if the driver or passengers in the car have been in trouble with the cops before for drugs? Is that enough of a reason for them to do a car search? Wagman 1803-2007, 08:23. BTW, this happened on the Gold Coast. Come ship, I'll be extra careful when going out and seeing the boys and Blue Splat 1803-2007, 08:39. What if the driver or passengers in the car have been in trouble with the cops before for drugs? Is that enough of a reason for them to do a car search? I don't know about that one, but I would sure like to know. I think it would have to be the owner's car though. because I don't think the cop has the right to search you if your friend was found with drugs. Lil Angel 1518-03 2007, 08:51 Searches. General Principles, Legal Rights and Duties of the Police. The police have no general power to randomly stop and search people for their homes. However, legislation exists that permits the police to search persons, places and vehicles when investigating crime. Such searches may occur either with or without a search warrant. In certain circumstances the police can lawfully conduct searches on the spot without a warrant. Substantial penalties apply to persons who resist or obstruct a legitimate and lawful police search. Types of searches. Essentially, there are three types of police searches: personal searches, vehicle searches, and premises searches. Searches of persons in custody. Searches of persons lawfully detained in custody are the subject of separate rules. Persons in custody may be searched and researched as is necessary to locate, seize and retain items which may be evidence of the commission of an offense, be used to facilitate escape, or endanger anyone's safety. Whether or not the measures employed by the police during the search of a person in custody are reasonable will depend on the likelihood that the person may attempt to commit an offense, escape or endanger the safety of another, in all the circumstances of the case. Unlawful searches. In every case where an illegitimate search is being conducted, it is permissible for a person to use force to resist. Moreover, persons who suffered as a result of an illegitimate search may have a criminal action in assault, as well as a civil action in trespass, against the offending police officer. One must always be very careful about resisting a search. However, because the police have very wide search powers, and heavy penalties apply for obstructing a legitimate search, police powers of entry, inquiry and inspection. Entry and search of public places. Police officers have general powers of entry, inquiry and inspection of public places. For example, an officer is permitted to enter any public place such as a nightclub, hotel, casino or showground to serve a document, or investigate an alleged offense, a missing person report, or a traffic incident report. Entry and search of other places. Police officers are also permitted to enter business offices, home garages and backyard areas for the above purposes. Upon entry, officers may stay in those places for a reasonable time. A reasonable time to stay at a place is determined according to the time that is necessary for the officer to perform the function with which he or she is involved. The police may not use excessive force to enter a place. The general powers of entry held by the police do not permit officers to enter a private dwelling without an occupier's consent. An officer is required to obtain a search warrant to enter a private dwelling, other than in the exceptional circumstances discussed below. Entry and search for arrest. Police officers are empowered to enter and stay on a private dwelling or other place, including a vehicle, to arrest or detain a person. An officer may only enter and search a private dwelling for arrest if holding a reasonable suspicion that the person being pursued is at the dwelling. Upon entry, the officer has the power to search the place for that person. Entry and search to enforce licensing laws. Police officers also have a broad-based power of entry and search to ensure compliance with statutory licensing rules, i.e., licensed premises serving liquor, second-hand dealerships, weapons licensees. For example, a police officer may enter and inspect a hotel to monitor compliance with the Liquor Act, or a licensed brothel to enforce the provisions of the Prostitution Act 1999 QLD. Searches under warrant. Issue of search warrants for places under the Police Powers and Responsibilities Act 2000 QLD. The police may apply for a search warrant allowing them to enter and search a place including a vehicle to obtain evidence of the commission of any offense, To obtain a search warrant, the officer must be able to show reasonable grounds for suspecting that evidence of the commission of an offense is at the place or is likely to be taken to the place within the next 72 hours. A Supreme Court judge must issue a search warrant if the search will cause structural damage to a building. The Justice of the Peace may issue a search warrant in most other circumstances. Importantly, a person searched under a search warrant issued by an inappropriate judicial officer may be able to challenge the validity of the search, and the admissibility of any evidence seized. Searching persons, vehicles and places without a warrant. Searching persons without a warrant. The Police Powers and Responsibilities Act permits police officers to search persons without a warrant. The authority of the police to search a person without a warrant is dependent upon the existence of a prescribed circumstance. If a police officer reasonably suspects that a prescribed circumstance exists, the prescribed circumstances in which an officer may search a person without a warrant includes circumstances in which the person is reasonably suspected to be in possession of a weapon, knife or explosive, an item which the person intends to use to cause harm to any person, a dangerous drug, stolen, illegally obtained or tainted property, evidence of the commission of an offense punishable by a minimum of 7 years imprisonment, which the police officer reasonably suspects may be concealed or destroyed if a search is not conducted, an implement of housebreaking, motor vehicle theft or drug use. Searching vehicles without a warrant. An identical set of rules apply to police searches of vehicles without a search warrant. A police officer may stop and search a vehicle, together with anything in it, if any of the above prescribed circumstances exist. When searching the vehicle, the police are allowed to enter and stay in the vehicle as often, and for as long, as is necessary to properly carry out their search. The police also have the power to move the vehicle to an appropriate place for a search, in particular if it is impracticable to search the vehicle where stopped. Searching public places without a warrant. It is legal for a police officer to enter and stay on a public place without a search warrant and for a reasonable time. If the place is accessible to the public when open, but is presently closed, the police officer may only search the place with the consent of the occupier, or by way of a search warrant. A cinema is an example of such a place. Search and seizure under the Drugs Misuse Act 1986 (QLD). The Drugs Misuse Act 1986 (QLD) gives the police wide-ranging powers of search and seizure in respect of vehicles, persons and places which may contain evidence of drug offenses. Police powers of search and seizure under the Drugs Misuse Act complement those already discussed. Importantly, the Act provides for searches both with and without a search warrant. Search of persons without a search warrant. If a police officer reasonably suspects that a person is in possession of a dangerous drug, evidence of a drug offense, a chemical used, or a piece of property contaminated by a chemical used in the manufacture of a dangerous drug, or any property or funds associated with a drug offense, the officer may stop and search the person, together with anything in possession of the person. If it is not practicable for the officer to conduct a search of the person where stopped, the officer may take the person, together with anything in possession of the person, to another place to be searched. Any evidence of a drug offense, or thing liable to forfeiture, may be seized. Body cavity searches without a search warrant. A police officer of the rank of inspector or higher who suspects that a person has a dangerous drug hidden within a body cavity, has the power to require that person to submit to a body cavity search. The search must be conducted by a person of the same sex as the person being searched, or a nominated medical practitioner and assistant. The search may be conducted using such force as is reasonably necessary. The machine, instrument or device may be used for the purpose of the search. Searches of places with a search warrant. A police officer may apply for a warrant authorizing the search of a place in connection with a drug offense. The Justice of the Peace may issue the warrant if satisfied that the officer has reasonable grounds to suspect that a search of the place may reveal evidence of a drug offense. Searches of places without a search warrant. The police have wide powers of search and seizure in respect of private dwellings and business premises under the Drugs Misuse Act. An officer may enter a place and search without a search warrant if the officer has a reasonable suspicion that either evidence of a drug offense, or anything liable to forfeiture is in the place, or in the possession of a person in, or about the place, and it will be concealed or destroyed unless the place is immediately entered and searched. Searches of vehicles without a search warrant. Similarly, a police officer may stop and search a vehicle, as well as anything in it, if the officer reasonably suspects that the vehicle contains evidence of a drug offense, or anything liable to forfeiture. Statutory safeguards for search. As safeguards for personal searches, the law requires that police officers do everything possible to protect the dignity and privacy of persons being searched. Accordingly, the police must take measures to ensure that the search causes minimal embarrassment to the person, and restrict searches conducted in public to an examination of outer clothing. Personal searches involving the removal of clothing. A police officer may require a person to remove some or all of their clothing for the purpose of a lawful search. In such circumstances, the officer must inform the person that they will be required to remove their clothing and why the search is necessary, as well as asking the person for their cooperation. Unless an immediate search is necessary, the officer conducting a search involving the removal of clothing must be the same sex as the person being searched, or a doctor. Moreover, such searches must be conducted in a way that provides reasonable privacy for the person being searched. Finally, the search must be conducted as quickly as possible, with the person being allowed to dress as soon as the search is completed. No officer is permitted to make contact with the genital or anal areas of the person, but may make a visual inspection. If clothing is seized during the search, the person must be given appropriate clothing to wear. Personal searches near video cameras. If the area in which a person is being searched is monitored by a video camera, that camera must be turned off, or the search conducted out of view of the camera. The rule applies unless the person viewing the monitor is a police officer of the same sex as the person being searched. Special requirements for searching children and impaired persons. A support person must be present at the search of a child, or at the search of any person who may not understand the purpose of the search. A support person for a child is usually a parent or guardian of the child, or a lawyer acting for the child. However, a police officer may conduct a search of a child or intellectually impaired persons without a support person given a reasonable suspicion that to delay the search would endanger the safety of a person, or result in evidence being lost, concealed or destroyed. Safeguards for vehicle searches. A police officer has the power to move the vehicle to any place for the purpose of a search. However, before moving the vehicle, the officer must consider whether the search will be more effective at the other place. The person from whom the vehicle was seized has a right to be told where the vehicle is to be taken, and to be present during the search. Obstructing searches of persons for vehicles. It is an offense to obstruct a lawful police search, or to fail to comply with a lawful police direction. A police officer must warn any person who does so. The person should then be given a reasonable opportunity to comply with a warning. After this point, the police officer may use force to overcome the person. Importantly, an attempt to conceal, destroy or dispose of evidence of an offense to which a search relates falls within the meaning of obstructing a police search. This does not mean, however, that a suspect must positively help police during a search by locating items, or answering questions, etc. Ryan and Bosch Lawyers, Brisbane. OshiaLegal.aol.com.au web link splash